Ladies and gentlemen, my name is Ross W. Crum. I am the Chief Judge of the United States Bankruptcy Court for the Western District of Virginia. There are two other judges in the Western District. Bankruptcy Judge William E. Anderson, who sits in Danville, Lynchburg, and Charlottesville, and Judge William F. Stone, Jr., who sits in Roanoke, Abington, and Big Stone Gap. One of us is assigned the responsibility to determine the confirmation of your proposed Chapter 13 plan. My purpose here today is to review with you your responsibilities as a Chapter 13 debtor so that you will achieve confirmation and then successfully complete your plan. The first thing I want to talk to you about is just generally an overview of Chapter 13. You have decided to use Chapter 13 to pay your creditors the debts that you owe. Your plan will run anywhere from 36 to 60 months. To pay your creditors, you will use the excess of your monthly income over your estimated monthly expenses to fund the plan. Your repayment plan will permit you to pay your creditors what you can while you still continue to pay your monthly living expenses. At the outset, I want to commend you on your decision to use Chapter 13 to pay your creditors. Let's talk a little bit about the steps to confirmation. By now, you have proposed a plan of repayment for your creditors, or you will propose one in the very near future. Perhaps you have already had your meeting of creditors with the Chapter 13 trustee and your creditors. If the trustee recommends confirmation of your plan and no creditor objects to your proposed plan, and you are current on your plan payments, once the judge determines that the statutory requirements for confirmation have been met, you are going to get a judge's signature on a confirmation order, which will provide you with a plan payment over your plan payment period. Now, one of the things that you have to understand about your plan once it's confirmed is that is what you have promised to pay your creditors. That will govern you and your creditors. That's all you have to pay in order to obtain a discharge of your dischargeable debts in Chapter 13, and that is the objective you seek to achieve. Let's talk a little bit about your Chapter 13 plan payment period. You're not alone in getting through this plan payment period successfully. Both the Chapter 13 trustee and your attorney are involved in your Chapter 13 case for the entire plan payment period to help you be successful in completing your plan payments. So, if you have a problem or a question during your plan payment period, it's important that you communicate both with the Chapter 13 trustee and with your attorney as early as you know that you have a question or that you have a problem. By early contact and communication, you can effectively help yourself stay at a Chapter 13 plan and not incur significant additional costs or court time. Now, what you should know is that while the Chapter 13 trustee is here to help you be successful, only your attorney can give you legal advice should you have a question or a problem. I cannot emphasize to you too much the need to get to your attorney early on with a question or problem. If you do that, you're going to save fees, and hopefully you're going to avoid missing work because you have to come to court to talk to the judge about a problem with your plan. Let's talk about your Chapter 13 responsibilities. As debtors, your obligation is to make your plan payments, which you've promised to make under the plan. First thing I want you to understand is that you need to make your plan payments on time. Now, in order to do this, you need to know what day of the month your plan payment is due. You need to talk to the trustee about that and make sure that you're clear as to when your plan payment is due. If you do not pay your payment on the due date and you have not talked to the trustee about your problem, then the trustee is going to have you back to court to talk with a judge about why your case should not be dismissed. I think the best way for you to be successful in making your plan payments is to use wage deduct. Your employer assists you in making your Chapter 13 plan payments by deducting a certain amount from each paycheck that you receive, and then your employer sends a payment to the trustee periodically to make your plan payment. In this way, you are always current. I want to talk to you a little bit about the mechanics of wage deduct. If you're on wage deduct or you're going to go on wage deduct at confirmation of your plan, I want you to check your pay stub each time you get your paycheck and make sure that there's been a deduction for your Chapter 13 plan payment. If there is a pay period when the deduction does not show up on your pay stub, the first thing I want you to do is set aside the money that would ordinarily come out of your paycheck and don't spend it until you go to your payroll department and find out why the Chapter 13 payment was not deducted from your pay stub. I also want you to call your attorney. Tell your attorney that this has happened, and if necessary, get your attorney involved in making sure that the wage deduct is working correctly. If at any time during your plan payment period you have any concern whatever about the fact that your wage deduct may not be working correctly, I want you to contact your attorney right away so that you can straighten it out. Now, the second thing I want you to do is I want you to keep all your pay stubs together in a safe place. They are your proof that the wage deduct has worked and that your plan payment has been made. If the trustee ever needs to check to see if the wage deduct is working correctly, the trustee is going to ask your attorney for your pay stubs. You need to have them available, so hold on to them. The third thing I want you to understand is that if you change jobs during your plan payment period, your wage deduct is going to stop. What you need to do is pick up a direct payment to the Chapter 13 trustee on the next pay period after you change jobs, and keep making direct payments to the trustee until you put another wage deduct in place. When you change jobs, there are two folks you need to call. You need to call the trustee's office and tell them that you have changed jobs and give them your new employer's name and address, and you need to call your attorney and tell your attorney the same thing and ask your attorney to take steps to put a new wage deduct in place. Finally, some of you may be considering wage deduct, but you're not on it now. You're going to be going to wage deduct at some point in time. What I want you to understand is that you got to make direct payments on your proposed plan payments until you go on wage deduct. When you see the money start to come out of your pay stub, then you can stop making direct payments. But don't stop making direct payments until you're sure your wage deduct is working. For those of you who are going to be on direct pay, if you use a money order, I want you to keep all of your money order receipts. Those are your proof that you have made your direct payments to the Chapter 13 trustee, and you can show those receipts to the Chapter 13 trustee if a question arises. Some of you are going to have plans where you provide for payments to secured creditors, and typically you'll have these payments made directly by you to the secured creditors. They're probably going to be car payments or home mortgage payments or mobile home mortgage payments. There are a couple of things that you need to remember about this. The payments to secured creditors you propose in your plan are plan payments. If you don't make those payments according to the terms of your obligation to the creditor that you don't pay can come back into court and ask for relief. Typically, the creditor wants to repossess your automobile or foreclose on your house. You don't want that to happen. So if you wake up one morning and you wonder how you're going to pay your monthly living expenses and pay your mortgage or your car payment, and you think you're going to have a problem, the next person to know about it that day is your lawyer. Call your lawyer, tell your lawyer what your question is or what your problem is or your concern is, and ask how Chapter 13 can help you. In this way, you're going to head off trouble. Don't delay, and don't think you can fix it yourself without talking to your lawyer. If you complete all of your planned payments, you are eligible to receive a discharge of those debts that you listed in your schedules and which, under the law, can be discharged in a Chapter 13 case. Now, a discharge means that legally you will no longer be personally obligated to pay the debts that you listed and paid through your Chapter 13 plan. When you get down to the end of your plan, I want you to be sure that you have talked to your attorney and have obtained from your attorney a list of any of the debts that are not covered by your discharge order, so that you're clear on that at the end of your case. After you get this discharge, as I said, you're no longer legally obligated to pay the debt. That doesn't mean that you can't decide to voluntarily pay the debts after your Chapter 13 is over. You can pay all of them, or you can only pay some of them. But it doesn't create a legal obligation to pay if you do that voluntarily. You can stop, or you can start, and you can pick and choose the creditors that you want to pay. So what I want you to remember about that is you can voluntarily repay, even though it's been discharged, but you can't be legally obligated to repay if you do that. The other thing that I want you to remember is that I never want you to sign any papers agreeing to repay a debt that has been discharged in Chapter 13 unless you consult your attorney about that. Now, what you're going to get at the end of your case, and when you qualify for the discharge, is a discharge order. That discharge order is proof that you have been through Chapter 13 and that you have obtained a discharge of the debt. If a creditor that you listed in your Chapter 13 statement, whose debt has been discharged, should attempt to collect the debt after you have received your discharge, you need to call your lawyer right away and inform your lawyer that that has happened. You need to ask your lawyer for help in getting the matter straight, because the attempt by the creditor to collect a discharged debt may very well be a violation of the bankruptcy code. You need to keep that discharge order in a safe place. You also need to keep all of the paperwork that you and your lawyer have prepared to get to confirmation of the plan, because that shows the creditors that you have listed. If you ever do get sued in state court by a creditor trying to collect a discharged debt, the discharge order and your Chapter 13 papers can be shown to the judge of the court where you have been sued, and that will help you resolve the matter in your favor very quickly. So hold on to your paperwork. Your lawyer will hold on to your paperwork in his or her office. So if you lose the paperwork or you can't find it in your home or wherever you've decided to keep it, call your lawyer's office and ask for new copies so you always have them. I have given you a lot of valuable information here today about your Chapter 13 plan and how to be successful in achieving confirmation and moving yourself to a discharge of your debts. I want you to remember what you've heard here today. So copies of what I've said will be given to you. This written copy at the bottom of the last page of instructions will contain the trustee's telephone number and name should you need to call your trustee. At the bottom of the page, there is also a space for your attorney's name and telephone number. You should see to it that your attorney's name and telephone number is filled in on that blank space. Then you need to keep this instruction, this written instruction that you're going to receive, in a safe place, a place where you can find it and use it if you need to. I want you to know that if you have any questions about what you have heard here today, you should talk to your attorney as soon as possible and get those questions answered. Also, after today, if, as you move towards your confirmation hearing, you need to amend your plan or do anything else to get ready for confirmation of your plan, you should be clear with your attorney as to what you need to do and when it needs to be done. That way, when you get to the confirmation hearing, you'll be ready to get that plan confirmed and move forward towards your discharge. Since you have heard this talk, you may not have to come to court on the day set for the confirmation of your plan. Your attorney will tell you whether you need to attend.